Please be seated. Court now calls case number CV140183, State versus Fisher. Counsel, these proceedings are being audio and video recorded, and there's a link to these proceedings on the court's website. So there'll be this audio and video recording that will be available in the next few days. Please identify yourself and your client before you present your argument. Each side has 20 minutes. Appellant, if you wish to reserve some time for rebuttal, you may do so. We've read the briefs, we've discussed the case, we're very familiar with the facts of this case. And if you wish to keep track of your time, you have a clock on the podium in front of you. Counsel?
Good afternoon. May it please the court. I'm Susan Luter on behalf of the state of Arizona. A rule cannot divest the state of its statutory right to appeal, regardless of whether that rule is invoked. Pursuant to ARS 134032, Section 2, the state has a statutory right to appeal an order granting a new trial. Rule 3116 simply gives an automatic stay of that order while the appeal is pending.
Well, did you need to dismiss the indictment without prejudice to bring your appeal?
We did not. Pursuant to the rule, we could have taken advantage of that rule, but because the state did not do so, it still does not affect the appeal. This court still has jurisdiction and the issue is not moot. It simply would have basically stayed the new trial order and would have stopped the speedy trial time from running. But once the state prevails on appeal...
Didn't a speedy time trial stop on the first day of trial?
On the first day of trial, but as soon as the new trial was ordered, the state had 60 days to try the defendant.
Right, but you could have used the rule to have maintained the status quo while you were seeking appeal of that determination.
We could have, but there's nothing that requires the state to take advantage of that rule. There's no statutory requirement, there's no constitutional requirement, and it certainly does not affect the defendant's due process rights. So once the state prevails on appeal and the new trial order is vacated, as in basically U.S. versus Wilson and U.S. versus Morrison, both of which are United States Supreme Court cases, all that would remain is the entry of judgment of conviction and the sentence. It would basically go back to before the trial court ordered the new trial. In U.S. versus Villamonte Marquez, the defendant argued that the appeal was moot because the state dismissed the case during the appeal. The U.S. Supreme Court rejected that argument. It found that the reversal would reinstate the judgment of conviction and the sentence. Here in State versus Fisher, once this court rules, the case would be placed back into its original posture as it was prior to the appeal. If the new trial order is vacated, the case would be set for sentencing. If affirmed, then the state would be back in the position of retrying the defendant within 60 days. By doing so, there's no prejudice to Fisher. If we were to follow the defendant or even the dissent's rationale in Villamonte, then the state could never appeal a suppression order because those cases are always dismissed in order to appeal. Therefore, this court does in fact have jurisdiction in the present case.
They don't have the same rule, though, for a motion to suppress, right?
They do not. And the rule is basically not a requirement. It's just saying that an appeal does not stop the clock from running. There's no stay in the order unless it's for a new trial or a suppression order where the evidence was directed to be returned.
I guess I have to ask you, why didn't you use the rule?
Honestly, it was just an inadvertence, or it was overlooked by both the state, presumably defense counsel, as well as the court. They just didn't recall the rule because it's so rare that a new trial is ordered. Most of the time it's a suppression issue, and in those cases we do dismiss. Now, looking at the cases in State versus Crotty, this court reversed the order dismissing the case and remanded with instruction to the trial court to reinstate the charges. A Division II case, which is State versus Gant, the issue of jurisdiction and mootness was raised, and based on Villamonte, that court found that it did in fact have jurisdiction and continued with the appeal. And finally, the Arizona Supreme Court in State versus Lelevere vacated the trial court's order suppressing the evidence as well as the order of dismissal. It then remanded the case back to the trial court for further proceedings. And in this case, we're asking this court, first of all, to find that it does have jurisdiction and that it's not moot, and then ultimately to vacate the new trial order and send it back, reinstate the case and send it back for sentencing. Thank you. I will reserve the rest of my time for rebuttal.
Counsel?
Good afternoon. My name is Stephen Biggs. I represent the appellee, Robert Fisher, who is in the courtroom today. I want to start off where the state left off about the mootness issue. The state has talked about Villamonte Marquez, and we were asked to brief that. Villamonte Marquez doesn't apply at all here because the key factor in Villamonte Marquez was there was a judgment of conviction entered. And the court said that the indictment would merge into the judgment of conviction and sentence. The procedural posture in Villamonte Marquez was entirely different than this case. In Villamonte Marquez, obviously, there was a judgment of conviction because after conviction, the district court entered judgment on the determination of guilt and then sentenced the defendant. After that, it went up to the Court of Appeals, which then reversed the judgment of conviction. Then the government allowed the mandate to issue, and then they petitioned the Supreme Court for review. In the Supreme Court, the defendant then argued, or the defendants argued, that the case was moot because there was no longer an indictment. And the majority concluded that it wasn't moot based on this merger doctrine, the idea that when the judgment of conviction was entered, the indictment merged into that judgment and sentence.
But the merger was just one of the grounds, as I understood it, for the rejection of mootness, as the majority justices said that, generally speaking, there was no requirement that the government seek a stay while they appealed, and said that notwithstanding that there was no stay and that the mandate was allowed to issue, that reversing the Ninth Circuit would result in reinstatement of the conviction.
Yeah, correct, and it would. It would result in reinstatement of a judgment of conviction.
It wasn't dependent on the merger doctrine. That was a separate analysis, which the dissent had a pretty good answer to.
Correct, but the key was there was a judgment of conviction there. And
key to the merger argument, I say.
And I think it was a key to the whole holding, because that is ordinarily what happens when you have a court of appeals reverse a judgment of conviction. And then if a subsequent court then reverses that. See, that case, it was all about what happened in the court of appeals, largely. And in this case, it's about what happened in the trial court. And the state's asking this court to entirely ignore the effect of its dismissal of the prosecution without prejudice. It's commonly recognized that when you dismiss a prosecution without prejudice, everything goes out the window. The case no longer exists. It's not there anymore. And part of that means that if you remand and there was a guilty verdict that was thrown out, you can't, that guilty verdict, there's nothing to remand it to. There's no judgment there. There's no pending charges. The state has a remedy. The state may now refile its charges and go through the whole process again. It also had the remedy that it could have simply used Rule 31.16. The state now says, we made a mistake, but give us the benefit of our mistake.
There's clearly nothing in that rule that requires that it be used.
No, I completely agree. The state was not required to use that rule. The state was also not required to dismiss the case without prejudice. The state did choose to take that route. It now has to live with the consequences. One of the consequences is that dismissal is there. Nothing about this appeal will vacate that dismissal. The state did not appeal the motion to dismiss. And the case law says the state can't appeal that motion to dismiss because it asked for it, and it got what it asked for, a dismissal without prejudice. The case wasn't dismissed with prejudice. The state simply is not an aggrieved party. There are other cases that the state relies on. United States v. Morrison, for example. In United States v. Morrison, there's no discussion of a voluntary dismissal. The case simply isn't on point. The case really has nothing to do with what happened here. Some of the other
way, because it talks about double jeopardy.
Correct.
So, that would be an argument that could be made if we granted relief and we said start over. I suspect you would argue jeopardy attached, and the state took the position it did, so you can't try him again regardless of what we might say.
Well, the Supreme Court has clearly held on that issue. The Supreme Court has held when a new trial is ordered based on weight of the evidence as opposed to sufficiency of the evidence, that you can retry and there's no jeopardy doesn't attach. That State v. Wilson is the U.S. Supreme Court case that held that. So really, there's not going to be a double jeopardy issue here. As much as I would love it if there was, there simply isn't. So double jeopardy is an issue. The state, what the state will get if this court holds that what the state has argued applies, is the state gets this whole new amount of time to attempt to wait however long it wants to recharge Mr. Fisher if it decides to do that. Then it has at least 150 days to bring him to trial under the Speedy Trial Rule, Rule 8. And it will also benefit from getting a new judge. It won't have to deal with the law of the case or collateral estoppel from any of the court's rulings that happened in this case that were adverse to the state. The state is getting all of these benefits suddenly. And I think there's a danger there from a public policy standpoint of saying, okay, state, there is a mechanism by which has been set up to make it so that when you want to appeal a new trial order, you can. We stay the speedy trial time limits. The defendant's release conditions can be reconsidered by the trial judge during that time so that there's not constitutional issues. And then at the end of that, you have 60 days to retry the defendant. Well, the state here has kind of jumped over all that and said, no, we want, if we lose, we want a do-over. If we win, we want all the benefits of winning. If we lose, we want a do-over because we don't like the outcome of what ultimately happened. I think you have some real due process issues there with allowing the state those benefits that Mr. Fisher doesn't have. Mr. Fisher couldn't have made that decision to, okay, well, I want more time or I want a do-over. It's only the state that's getting that benefit. And the state has relied on several cases that talk about where there's been a appeal after a voluntary dismissal or a dismissal that this court or other courts of this state have said, we remand for further proceedings, such language. All the cases the state has cited are distinguishable. For example, in Lee versus Superior Court, that case involved the appeal from an involuntary dismissal. The state was appealing a dismissal that came at the defendant's request. Of course, in that circumstance, you can remand and you go back to the state because the state is challenging the dismissal itself. And therefore, the remedy on appeal is the order of dismissal gets vacated. So Lee is distinguishable. It's not the same. In fact, Lee actually supports Mr. Fisher's argument because in Lee, the Court of Appeals explained if the municipal court suppression order was affirmed on appeal, the state could decide whether to refile a DUI charge or not based on the petitioner's blood alcohol concentration. Alternatively, if the order was reversed, the state could either refile one or both of the DUI charges or choose not to disturb the earlier dismissal.
Isn't the state asking us to reinstate the verdict and not the indictment?
I believe that's what the state is asking you to do, is to simply reinstate the verdict.
We have jurisdiction to hear the state's appeal on this granting of a motion for new trial, don't we?
Correct. You have jurisdiction. We're not arguing.
And they're asking us to overturn the court's order and reinstate the verdict.
Correct. And the problem with that is
Can't do that?
you can't because the order of dismissal is not. Now in Arizona, we're not just dismissing an indictment. If you look at the rule, it's dismissal of the prosecution.
Well, the verdict by the granting of the motion for new trial has been dismissed, right?
Correct.
But the state's asking us to reinstate a verdict that doesn't exist anymore, right?
Correct.
I guess I'm not following you. Why can't an appellate court reinstate a verdict that a trial court has thrown out?
Normally, an appellate court can do that. So under normal circumstances, had the state not dismissed the prosecution, this court could reinstate the guilty verdict. It would reinstate the guilty verdict, and then you go proceed to sentencing. The problem here is that the prosecution itself has been dismissed. It's like in a civil case where the actual case is dismissed. And I think Judge Brennan's hypothetical example in the dissenting opinion of Villamonte Marquez is instructive. In Villamonte Marquez,
If the verdict is reinstated, then that dismissal is of no effect whatsoever. Isn't that correct, counsel?
oh, that would be incorrect. For example, if the verdict happened, you would go back to where the verdict happened. But after the verdict happened, there was a dismissal. So you had a verdict come in, then you had a dismissal, and it was all gone. The state decided to wipe the slate clean. It didn't have to do that, but that's what it did. It wiped the slate clean, and there's simply no prosecution. There's case law from other jurisdictions. I will acknowledge that there is not case law on this issue directly on this issue from Arizona. There's case law from other jurisdictions that make clear, and it seems to be the consensus among courts in other jurisdictions, that when you dismiss a prosecution, or the equivalent, some states call it a null prosequi, and when you have that happen, any further proceedings are a nullity. And you can't go back, and if you try and do anything further from that point on, it's a nullity and it's of no effect. The state can, because it was a dismissal without prejudice, prosecute the defendant, but it has to be in a new case under a new indictment or information or charging document. And so that's the case here, is that there really is no case to remand it to. You could, I guess, you reinstate it, but you're sending it back to a case that just doesn't exist anymore. And so that's the problem there. So some of the other cases that the state cited, if you have more questions on that issue, Judge Gould, I'd be more than happy to address them first. But
I would hope at some point you would discuss the role of the trial judge in considering a motion for new trial, the role of the trial judge in weighing evidence, and what the limitations of a judge's authority are in that area.
yes, I will address that now. The state has asked you to adopt a new standard of review for the trial court, when the trial court is looking at a motion for a new trial based on weight of the evidence.
And clearly the trial judge has more breadth of authority with regard to a motion for new trial and weighing of the evidence than in the situation of a directed verdict.
Correct. And the reason is as the cases, that's why the analogy is made to a 13th juror, or in this case, I guess, a 9th juror, is that the trial judge hears all the evidence, and like the jurors, is expected on a motion that's based on weight of the evidence to look at it the same way the jury would and decide. Oh,
Go ahead.
and decide if the trial judge, after weighing credibility and giving weight to the evidence that it feels each piece of evidence is accorded, whether the state has proven its case beyond a reasonable doubt. If the trial judge decides, in its opinion, after weighing the evidence, that the state has not proven its case beyond a reasonable doubt, the trial judge has an obligation to order a new trial.
The one difference between how a juror reaches his or her conclusions and that when a trial judge does the same is that we don't really hear officially from any juror as to that juror's conclusions about specific pieces of evidence. We might hear later informally if somebody talks to them, but here we have the judge speaking at some length about various evidentiary considerations. And although the judge certainly has the authority to weigh the evidence, how are we to view some of these somewhat problematical conclusions? For example, the trial judge seemed to have placed considerable weight on the absence of the defendant's DNA and fingerprints on the gun. Is that correct?
Correct. The trial judge did place great weight on that.
I think there's evidence in the case, and it would, I guess, be my understanding that the absence of DNA and fingerprints on any particular item doesn't prove that the person didn't touch that, because a fingerprint and I guess DNA evidence is kind of a chance transfer. And so isn't there a problem with how the judge reweighed that evidence or weighed that evidence?
I don't think there's a problem because I acknowledge what you're speaking about, Judge Thompson, and I do acknowledge there was testimony in the record about the fact that, you could touch something and not leave DNA or a fingerprint. When you look at that finding, though, as a whole, and the weight she accorded that, the fact of the matter is there was no evidence on the gun itself that connected Mr. Fisher to having fired the gun, which, to prove second-degree murder, the state had to prove that Mr. Fisher fired the gun under its theory.
But not just from the gun.
Correct, not just from the gun. But that was one piece of evidence that she looked at and she said, look, on this, I don't find any evidence that says Mr. Fisher fired the gun. The evidence that is on the gun, however, seems to me to indicate that Mr. Lee could have fired the gun. If she gives any credibility to
The gun
that.
was found in his hand, right?
Correct.
So that, I mean, could have, I guess, into the theoretical view of the evidence.
Yes,
But
and
the jury seemed to have found otherwise.
The jury did find otherwise, and juries make mistakes, quite frankly. And if you look at the evidence was that the technician who swabbed for DNA was trying to swab areas that were not from blood. And if you look at the photos of the hammer, of the magazine particularly, it's pretty easy to swab for areas that don't appear to have blood because there was not a whole lot of blood on the hammer. They tested some of the swabs that had the DNA, and they tested negative for blood. So there was swabs that showed non-blood DNA on it. So, and I acknowledge that the gun was in his hand, but the point is that Mr. Fisher was not required to prove beyond a reasonable doubt that Lee Ratter killed himself. All that had to happen was there had to be some credible evidence that a reasonable juror or judge reviewing could believe, look at, and say, I believe this creates reasonable doubt. As soon as that happens for the trial judge has an obligation to order a new trial to prevent a miscarriage of justice. And if you look at the evidence as a whole here, the state's theory in this case rested largely on Detective Acosta's testimony, his expert testimony, and his theory that this was a staged crime scene.
But what about other evidence that it appears the trial judge perhaps didn't give significant consideration to? Isn't there evidence in this record that your client washed his hands after the officers arrived?
There's conflicting evidence that he may have washed his hands after the officers arrived.
And so to a jury, that could infer a consciousness of guilt, correct?
Yes, that could infer. And I'm not making an argument that there wasn't sufficient evidence, because that was not the judge's finding.
But isn't the trial judge, in weighing the evidence, doesn't, as you just said, does need to look at the totality of the evidence, right?
Yes.
And you have been doing this as you were talking to us. And when the trial judge singles out particular pieces of evidence and discusses the problems that she had with it or the inferences that she was drawing for it, doesn't she have to put it in the whole context of all the evidence?
I think that in a criminal case, if you find even one piece of evidence that creates reasonable doubt, if you're a jury, you're instructed to acquit.
Except that the consideration of each piece of evidence has to be in the context of all the evidence, does it not?
Well, we instruct juries in Arizona that they are to give evidence the weight they decide. They don't have to give one piece of evidence more weight than another. I have seen no case law that says it's any different for a trial judge reviewing a motion for a new trial based on the weight of the evidence. The case law says the trial judge acts as the proverbial 13th juror. And I believe that the trial judge is afforded that discretion. The case law says broad discretion. And she can afford more weight to some evidence than other based on having heard the totality of all the evidence. She can decide.
I agree with that, counsel, but the word weight means that you're considering all of it.
Correct.
You would agree that on a motion for a new trial, a trial judge can't disregard some evidence and only weigh some. The trial judge has to consider all the evidence and determine whether that verdict is against the weight, all the evidence, not I'm only going to consider these pieces of evidence. I'm not going to consider these three. That would be an abuse of discretion. Would you agree? Not considering all the evidence? Yes.
Refusing to consider evidence, I think, could be an abuse of discretion unless the evidence the trial judge relied on created reasonable doubt. In that case, any bit of reasonable doubt.
How can you determine reasonable doubt if you're excluding some of the evidence?
Well, I think you can have one piece of evidence that can clearly show reasonable doubt.
And not consider all the other evidence in the case?
I think the trial judge did consider all the evidence. She said she did.
That's not what I asked you. I asked you, can you reach a conclusion on one piece of evidence and say this creates reasonable doubt by excluding all the other evidence in the case or half the evidence in the case? Can a judge do that?
No, I think a judge should consider all the evidence in the case.
Well, whether they should, they have to, correct?
In ruling on this motion, yes, they would consider all the evidence in the case. My argument is simply they look at all the evidence, but they're naturally going to afford some evidence more weight than others. I think that's particularly important in this case because when you read the transcript, there's a whole lot of demonstrations that on, just the pages that we read in the transcript, you can't exactly tell what is being demonstrated. The trial judge was there. She saw it. She saw the witness's demeanor. She saw how they presented their testimony, and she was able to judge the credibility. On a cold record, That's something this court and the state Supreme Court has often said, that appellate courts are not in a position to second guess those credibility determinations because we have a cold record on appeal. And it's really impossible to recreate those situations. They're not there. So in this case, I believe that Judge Mullins did a wonderful job of reviewing all of the evidence. She may have weighed some evidence in a way that that other people would have weighed a different way, but she had the discretion to do that. She gave you a 31-page, very detailed minute entry explaining her decision. And I would ask this court first to dismiss this case as moot, and second, if this court considers the case, to affirm. I believe my time is up.
All right, thank you. Counsel?
With respect to the earlier questions regarding jurisdiction, I would just like to point out to the court that while the dissent in Villamonte pointed out the state had an option of simply letting the matter rest pending the appeal, the decision by the court and the majority found that it was not moot. As a matter of fact, while counsel says that because there was a judgment and sentence entered, that's the difference in this case. However, the majority in Villamonte specifically said the defendant's sentence and entry of judgment only means that it obviates any need for a separate reinstatement of the original indictment. And when you look at the cases that were cited by defendant, they talk about mainly one, Allman, I believe, which is out of Wyoming. However, that case specifically stated that they were not addressing the idea of resurrecting the dismissed counts. They never went there. And so in this case, that's what we're asking for. Counsel also talked about how we get the option of refiling, and that's what our plan was, so we have 150 days. That is not what we're saying. What the state contends is that this court has jurisdiction, and once it rules, if it rules in favor of the defendant and upholds the new trial order, we go back to that position, and we have 60 days to retry him as if we never appealed. But we do believe that this court should overturn the new trial order in that the judge did, in fact, abuse her discretion. When looking at the test and all the evidence, it is true that she got some of it wrong. For example, that there was no DNA on the weapon. When looking at that's contrary to the testimony. And we also know that this weapon belonged to the defendant, and he only handled it that morning. So the fact that his DNA is not on the gun, first of all, doesn't mean he never touched it. That's not what lack of DNA means. But it could be inferred by the jury that it was wiped clean at some point. Because it's unusual when you own an item and it's in your possession over a long period of time that your DNA would not be there. And so that's questionable. The other items of evidence that were ignored was the blood drain patterns that could only occur when the hand was open. When the victim was laying forward.
That's what your expert's opinion was. That's not what the defense expert opined. He opined the complete opposite of that.
He did. And it was not clear, but he did try to explain how the blood patterns could have happened when Lee flew through the air. And that's how it could have drained on both sides of his hands, especially.
Yeah, it seems to me that the trial judge has the authority to draw different inferences from pieces of evidence than the jury may have done. The question, I think, is viewing the totality of the evidence. Were the judge's conclusions, given the inferences that the trial judge drew, were they within the trial judge's discretion? So I don't think it's necessarily answers the question before us to observe that the trial judge drew different inferences as to some evidence than the jury apparently did. But looking at the totality of things, can we conclude or not that the grant of the new trial was within the trial judge's discretion?
I think you can conclude the fact that she did not evaluate all the evidence as an abuse of discretion and that she should not have ordered a new trial. Even if you don't want to look at the evidence where the state argued that she got it wrong and just take it at face value on how she evaluated it, that's where it goes to the second part of our argument. You need to take the evidence as she found it, all of it, and weigh it. And once you weigh that evidence, it will in fact show that the defendant was guilty, and there's nothing to show that there was reasonable doubt.
What did she fail to weigh?
She failed to weigh the blood drain patterns. She failed to weigh basically the position of the body. You can ignore the fact on how it got there, but we know for a fact that Lee was forward and he bled onto the floor. We know that he is now backwards and the gun has been placed in his hand. If you look at the weapon, and in evidence is a plastic gun that is the true weight that came out in testimony, it's a true weight of the gun. If a person, the jury could have considered a person laying forward with the gun in their hand who has no voluntary movement could not possibly hold that gun and then end up on the floor no matter how he ended up there. We know he was forward and then somehow he ended up backwards on the floor. There's also the washing of the defendant's hands. We know that there are blood drops, Lee's blood drops in the defendant's footprints that did not occur from Lee, the victim. It did not happen there. It had to be from when the defendant was walking around after he had blood. He then showed a consciousness of guilt by washing his hands when he was specifically told not to. I think the jury could have also looked at the fact that he is an ex-officer and he's an attorney, and therefore he should have known better not to wash his hands, and he certainly knew enough to ask.
Well, we generally presume that the trial court follows the law, and although we have this analysis, why can't we presume that the court considered all of the evidence while discussing what she has that resulted in her motion?
Well, when looking at her minute entry, you know what evidence she looked at and what evidence she did not discuss. But when you look at the record, which this court does when evaluating whether there was sufficient evidence to sustain a conviction, when you look at that evidence, it shows that there was sufficient evidence to uphold the verdict, even if you discount the evidence that she found was not credible. Because you do still, and under the test by the state, is you take it in the light most favorable to sustaining the verdict. And that's part of the test. Even if you exclude the evidence she found not credible, take what's left over, that is more than enough to sustain the conviction. Most cases where it's overturned due to the judge acting as a 13th juror, when you take away the evidence that they found not credible, it guts the case. There's nothing left over. For example, the case involving the ID and the person having a beard. Once the eyewitness testimony was gone, there's nothing left. There's no other evidence. But here there's a sufficient amount of evidence, more than enough, to show that the jury got it right. And they certainly, as Judge Thompson pointed out, we don't know what they were thinking. They may have thought the footprint evidence didn't make sense either and just simply discounted it as well. But still, with all the remaining evidence, there was enough to convict this defendant. And that's why the state is asking that you reinstitute the guilty verdict and send it back for sentencing. If this court has no further questions.
Thank you.
Thank you.
We'll take this matter under advisement. We'll issue a written decision in due course. Court's in recess.